Very good, very good. Your 5 minutes are up. You've had 35 minutes to discuss the very, very difficult topics the speaker spoke about this morning, and I've no doubt there are questions and answers. So I will invite questions and answers from the floor, and there are microphones. So put up your hand if you want to ask a question, and you'll get a microphone. Yes. Go ahead. Yes, go ahead.
Thank you, Judge. I'm the facilitator for Table 10, and this is a question which I think could be directed at Eileen Barrington. From the citizens at this table, a question has arisen. Let's say that we go through the process of the Assembly, that the Assembly decides that we should have a referendum, and that the choice goes to the people of this country to change the Constitution or not to change the Constitution. If the decision is leave the Constitution as it is on this topic, where does that leave us in relation to issues like the Mellet case? Thank you.
Eileen, have you any difficulty with that? Yes.
Thank you. I think it's a question we can perhaps both address. Certainly, the response given by the state to date to the committee in respect of the Mellet decision is that the matter is under review. Undoubtedly, the Mellet decision states that, in effect, the law should be changed. And if after a referendum there is no change to the law, then it may very well be that the committee continues to consider that Ireland is in breach of the covenant. It should perhaps also be added that, as you will have heard perhaps at an earlier session, that the question of the substantive law was considered by the Court of Human Rights in the A, B and C case, because the cases brought by Ms. A and Ms. B were cases where they had wished to undergo a termination, travelled for a termination, and it was clear that they weren't entitled to it under the law of this state. And the European Court of Human Rights held that that was not a breach of the Convention because as an international organisation, it affords what's referred to as a margin of appreciation or a margin of manoeuvre to contracting parties. So from a European Convention law perspective, it is to date the case that the substantive law is not considered to be a breach of the Convention. That is clearly not the case insofar as the committee that polices the International Covenant is concerned. When it came to defending the case before the European Court of Human Rights, the state made the argument that the people have voted on this issue on a number of occasions, and it is a significant moral choice made by the people, and that should be respected. One can only assume that if there were a referendum and the people voted against an amendment of the of Article 43.3, that the state would be obliged to go back to the committee and to seek to defend its position. But it may very well be that the committee continues to consider that Ireland is in breach of the covenant.
Very good. Noah, do you have anything to add?
Just in relation to the Human Rights Committee of the UN, Ireland and every state that has ratified this particular instrument has to do a state report every number of years. And the committee responds to that report every number of years and makes observations on Ireland's law, and that will come up again and again. It will also come up in other UN committees that deal with human rights issues. It will also come up as part of what we call the Universal Periodic Review process, whereby every state in the world has to go on a human rights kind of review every 4 years. And the issue of Irish law and abortion came up again this year when Ireland was reviewed. So there's a huge amount of international pressure, I guess, would be the answer to that, for Ireland to review their laws. But again, Ireland would always be defending their particular laws on this particular issue in every report they write back to that committee and other UN committees.
All right, before we leave that, can I just ask Table 12, Table 10, are you happy with that? Is that what your minds were focused at? Or were you thinking of the position under Irish law and the interpretation of the Constitution?
The question arose because just wondering where do we go from here?
Sorry, I can't hear.
The question came to me asking where do we go from here.
All right.
In the Mellon case, we've accepted we're wrong.
Yeah.
But if
Right.
the people decide we're not wrong, just
Yeah.
where are we like?
Yeah, very good. And you have answered. That was what your focus was. I wasn't quite absolutely clear on that. Yes, we'll take another question. Yeah.
Thank you, Justice Lafoy. As the facilitator for Table 12, we actually had a fairly identical question to Table 10, so I would like to thank people for the clarification on that. And then for the medical experts, specifically in regard to Down syndrome, does the current NIPT test give an indication as to the severity of the Down syndrome, i.e. where on the spectrum might the person be?
Very simple answer, no. So, and again, I'd like to just point out this newish NIP test is still a screening test. It doesn't tell you that definitively the baby has or has not. So, in order to make that diagnosis, you need to have one of the invasive procedures. And even when you get the answer from that, and it's a very common question that we're asked, doctor, you've told me my baby has Down syndrome, can you tell me how severe it will be? And the answer is we can't. Now, sometimes anatomically we can look and the baby might have lots of challenges because it has a very abnormal heart. So you can sometimes fine tune, but in terms of predicting that baby's life and function, you can't divide it into mild, moderate and severe, no.
And to clarify that, even when the baby's born and you're making that diagnosis, you can't predict that for any child with Down syndrome.
Facilitator for Table 11, we've 3 questions. The first one is a legal question. If we were able to make legislative change in cases of fatal fetal abnormality, does the panel have a view on how we would address the issue where there's disagreement between the parents of whether to continue with the pregnancy or not? Our next question is, our assumption is where testing is not available in Ireland, we're assuming that this is because of funding, and if that could be confirmed. And the third question is access to services a human rights issue under EU law?
Well, we'll deal with the first question. I'm not 100% sure it comes within our task. It's a matter of, it would probably be a matter of general law rather than anything specific to the issues we're concerned with. But I'll hear both Eileen and Noel whether they agree with that.
Yes.
The issue of that's the issue of consent if there's disagreement between the parents.
Yes, I think that I agree that that is a matter of general law, if you like. Certainly, insofar as the existing legislation is concerned, that issue isn't addressed in the existing legislation.
Yes, yes.
Can I just say that when we have a baby and we're looking for consent for a procedure, if the parents aren't married, the father can't sign that consent form, only the mother can.
Yes.
If the parents are married, the father is allowed to sign the consent. So there is that precedent there that if they're not married, then only the mother can consent to a procedure for her baby.
Yeah, I think if an issue arose, it would end up in the High Court.
Yeah.
For a ruling of the court on it. So it's difficult to give an answer because, as I say, it relates to the general issue of consent in relation to children and relations and all of that. Very good. The third question, I think you got a fair deal on getting answers to 2 other people. So we'll go on to the next.
Hi, my name's Louise. I'm from Table 6. My question is for Dr. McParland. You mentioned at the time of the diagnosis for fetal abnormalities that often the patients aren't aware of the law in Ireland and they get angry or they're disappointed at the time that they can't continue the care, if you like, within Ireland. My question is, I know you may not have statistics on this, but even anecdotally, of the women who choose to continue with the pregnancy, which, as you've said, is the vast majority, I wonder how many of those, in your experience or in your mind, how many of those decide not to terminate the pregnancy because of, I suppose, the inaccessibility of this option in Ireland?
I don't have figures. There is not research published on that specific area. I would think that if termination was more accessible and therefore more palatable, more patients would avail of termination. To put a percentage on it, I can't, but I would imagine if it became the norm, if it was the socially acceptable, as it is in many other countries, not even just socially acceptable, probably socially preferable in many countries. That's not the situation here. But I think if you made it accessible here, I think more people would avail. I can't put a percentage on it.
Very good. Just before we leave, Dr. McParland, I should perhaps go back to question 2 from table 11, which was about the test not being available. And
yeah, I'm sorry to sort of.
Is it a matter of money?
It's partly a matter of money. It is partly a matter of resources. It's, as I mentioned, a shortage of skilled people, midwives, sonographers, who need to be rewarded for undergoing a lot of extra training. But I think in many of the general hospitals, they're competing for a budget when they have an emergency department with 40 people sitting on trolleys, and they've got to decide in their budget, well, do we put some extra resources into the ED crisis that we have at the moment, or do we put it into prenatal testing? And very often it's the poor relation and the money goes elsewhere. So I think there is a resource issue, there's a skill shortage, but that's again down to resources.
Yes, we'll take another question.
Hi, how are you? I'm a member from Table 4. It's a question for Dr. McParland, sorry. We just wanted to ask for a little clarity on what exactly you meant by the social kind of implications of the NIP testing. Just the effect on society. Thank you.
Well, in Iceland, in the last 4 or 5 years, I'm led to believe there have been no babies born with Down syndrome. And I think only a handful in Denmark. And Down syndrome is not what we're discussing at this assembly. It's not a lethal, it's not fatal, or whatever words you want to put on it. But women in this country are choosing to have the test. It's widely available. It's not available on the state, but people are choosing to pay for the test because they want the reassurance that their baby is okay. When their baby is not okay, then they have this difficult dilemma. And the point I was trying to make was that in some countries, Down syndrome, in 10 or 15 years, there will be no children with Down syndrome at all. Ireland is not in that situation, but we have 30 out of potentially 100 who were not born in 2015 because women chose to terminate. So I don't know if that answers the question. We're way behind what is happening in other countries, but there's a trend there. And the science has got way ahead of the discussion, the ethics discussion. The scientific breakthroughs are fantastic and they're wonderful, but as a society we haven't reflected on what the implications are. And there is a situation where Down syndrome will become less prevalent.
Another question.
How are we doing? Dave, Assembly Member, Table 6. The question would be for Noel. Regarding fetal abnormality, are you aware of any legislation regarding that specific matter in European law that might have to be considered by any legislation makers in Ireland, seeing as you said that European law supersedes Irish law?
No. So the European Union law doesn't deal with the substantive issue of abortion, and it leaves it up to member states. So if you look at various different member states of the European Union, they will have various different types of legislation on abortion, some of which will allow for abortion at various different stages. Ireland and Poland, I suppose, would be the two states that would be the more restrictive in that, but there wouldn't be any substantive EU law on the issue of abortion or fatal fetal abnormalities.
Very good. Any other question?
I'm the facilitator for Table 7. The citizens of this table have a number of questions.
Well, we'll take the first one first anyway, because we don't want to be unfair.
No. In terms of the first question, in terms of the cost for tests and their availability, and if it's standard and if it's available at the mother's request, the risks associated with the tests and the turnaround time of same.
All right. Well, that's interesting, yes.
Okay, well, the tests are well, if we talk about the 3 tests that are widely, ultrasound is available. It's available in every of the 19 maternity hospitals, and it's widely practiced. We have a health system which has a public and a private dimension, so fee-paying patients will sometimes pay for those services, but public patients will not, and they would have, certainly at my own hospital, equal access to the testing. The same would go for the invasive procedures. With regard to this newish test, NIPT, it's an opt-in. It's a service that's available. Patients will pay for it. Because it's new technology, although it's a simple blood test, it originally costed about €1,000. It's not a simple blood test. There's a lot of technology behind it. And all that R&D costs had to be recouped. But because more and more people around the world are availing of the test is now available for about 350 to 400 euros. But the patient needs to, at this moment in time, pay for it. In many other European countries, they're bringing in, as I said, in the NHS, that is going to be a standard of care where they will be offered this type of testing. That's not in the plans for this country at the moment.
And the time is the time.
Oh, the turnaround time. Well, ultrasound is spontaneous. You get your answer there on the spot. The invasive test, again, you can get a turnaround in 4 or 5 days to get the result, and same 4 or 5 working days for the blood test, the NIPT test.
Very good. Yeah.
How are you doing? Jared Kern. This is a question for Noel. You mentioned that with the European Convention on Human Rights that the Irish law has to be compatible with this, and that a declaration of incompatibility can be made, and that from that either reparation or a change to the law can be made. And in the Mellick case there was reparation offered, but I was wondering, has there ever been a change to the law from a declaration of incompatibility, or has it just been reparation offered?
Yeah.
Thanks.
Well, with Mellitt, I suppose Mellitt came before the Human Rights Committee of the UN, but in a similar way with relation to the European Convention on Human Rights, there have been very few declarations of incompatibility ever made. But yes, I suppose in relation to a recommendation that the law would be changed, that was the question, was it? That there, yeah.
To the law from, has there been a change to the law from this declaration being made?
Well, I suppose the declaration of incompatibility has never been made in relation to this particular issue.
Well, on any issue, I mean,
yes,
has there been a change?
There would have been in relation to the Lydia Foy case, there would have been a declaration of incompatibility made and subsequent changes to the law, but there have been very, very few declarations of incompatibility
And
made.
there would have been one also in relation to the Donegan case.
Exactly, yeah. And again, a subsequent change to the law. So there's only been 2 since, 2 declarations actually.
Have there only been 2?
Has there been another?
Lydia Foy and Donegan.
And Donegan, they would be there.
Okay, thanks
I
very
can
much.
claim credit for Donegan.
Yeah.
In the High Court.
My name is William O'Halloran from Table 1. My question is for Dr. Peter McParland, just with regard to the 135 women who travelled to England to have a termination of pregnancy under Section E of the 1967 Abortion Act. It's just a more general question in the context that you said that 112 of these were over 20 weeks. Could you give us an indication as to the different stages in pregnancy? When does a heartbeat start happening in the womb? When is full brain development completed in the womb? And any other important milestones in the development of a fetus?
Well, I suppose you can see a heartbeat on an ultrasound machine from about 6 weeks on. So that would be 4 weeks after conception. We traditionally go from the last period. So at 6 weeks into the pregnancy, you can generally see a heartbeat quite clearly. By about 10, 12 weeks, you can certainly see the outline of a baby. You can see the head, you can see the body, you can see the limbs. You can't see the fine definition of the anatomy, but you can certainly see what resembles it, what is a baby, and resembles a baby with a head, body, and limbs. And over the next 10, 12 weeks, you start to see the anatomy a little bit more clearly. And certainly by 22 weeks, you can kind of interrogate the fetus, if that's the way to put it. You can scan and get a good look at the brain. You can look at the heart. The heart is quite a difficult, complex organ, but you can see this fairly clearly. And you can give reassurance to lots of mothers. But as I hope I highlighted, ultrasound is not the be-all and end-all. And we miss things on ultrasound. For instance, we don't diagnose babies who have cystic fibrosis, because babies with cystic fibrosis look completely normal. We don't diagnose babies with cerebral palsy or autism and a whole host of other, because anatomically those babies are all absolutely perfectly normal. And just to clarify a point on the 112 out of the 135, it was more 112 out of the total number, and my slide probably didn't reflect that well, who had late terminations. But I suspect that many of the 112 were possibly medically, in inverted commas, indicated terminations. Why? Because many people will get their diagnosis at that 20-week scan, and then they go through a process of deliberation in terms of what they will do. And by the time it's organised, you're often talking about 21, 22, 23, and dare I say beyond. So I hope that answers. Thank you.
I'm the facilitator for Table 2, and there's a number of questions here, both legal and medical. The first question is for Dr. McFarland, and it relates to the NIP testing. Can this take place earlier than 10 weeks? And also, if the testing at various stages takes place, will the results differ?
No, I think 10 weeks is the cut-off. I mean, the longer you leave it, the more DNA that floats from the placenta into the baby. Theoretically, it can be done a bit earlier, but you'll often get no result if you start doing it at 9 and 8 and 7 weeks. Theoretically, it's possible, but 10 weeks would be what is generally recommended. At that stage, there's enough fetal DNA in the maternal, in the mother's blood, to analyse. Before then, you just don't have it. And the results will be pretty similar the whole way through the pregnancy. And the test is available through the whole pregnancy, because that DNA exists in the mother's blood through the pregnancy.
The second question that was raised by the members of the table was for Noel, and it was asked if an amendment was made to the Constitution to permit cases of fatal fetal abnormalities, would it satisfy the Convention of Human Rights, or would broader change be required? And also, in relation to changes to the Constitution, can the European Union overrule these?
So, sorry, just the first one, if there was changes made to the Constitution, would that
satisfy the Convention of Human Rights? In relation, I think that's more in relation to the Mellick case, is what the members wanted to.
Okay, so
raise.
So I suppose with the Mellick case, it was the International Covenant on Civil and Political Rights, and with that, the issue is that Ireland hasn't incorporated into our domestic legal system. So, an individual can't rely on it or can't base their full case on that. They have to have other legal sources involved. What the Human Rights Committee recommended was that we should reform our laws. It didn't say how, and it didn't, specify that we have to look at our Constitution. It had kind of just a general recommendation that we reform And the response, as mentioned earlier, was by the Minister that, well, this is what we're looking at. We are looking at reforming it through the Citizens' Assembly. So because the committee didn't specify a way, to reform the laws, it really is up to Ireland to decide that.
Yes. Eileen, would you like to add to that?
Thank you. In my view, the answer is yes, because while the committee wasn't telling Ireland how to go about it, the committee was clearly saying that something should be done so that a person such as Ms. Mellett didn't find herself in that situation again. And if the law, the Constitution, were to be amended so as to allow terminations in this jurisdiction for somebody whose fetus suffered from a condition such as Ms. Mellett's, I think that would deal with the committee's concerns.
It might be worth bearing in mind that before the 2013 Act, the interpretation of the Constitution of Article 40, Section 3, Subsection 3, gave us, it was the decision in the X case that gave us an interpretation and permitted Miss X to travel to have her abortion. Yeah.
I'm the facilitator for Table 9. We have 3 questions. 2 relate to the law. 1 is more relating to the medical aspect of matters. The first question is the reason that there aren't more cases taken regarding abortion and the current situation due to the fact of the financial burden of actually taking a case in the first place? We also have a question as to what is the general situation across Europe regarding abortion being legal, as in what proportion of countries is it legal versus not being legal. And finally, there's a query, the Medical Council of Ireland, whether they have any influence with the government on legislation relating to medical matters, and I suppose how they would implement that influence if they do. Thank you very much.
Well, I suppose that's the last one is more a political question than a legal question. Yeah, Eileen, yeah.
Perhaps deal with the first one. You've asked whether the financial issues are inhibiting proceedings being brought. Part of the argument in the D case, you remember the state had argued indeed that Ms. D could have brought proceedings in Ireland. Ms. D argued that she wouldn't have succeeded had she brought proceedings in Ireland, but she also argued that there were a lot of downsides to bringing proceedings in Ireland. She argued that the speed of getting a determination from the courts was a factor inhibiting her bringing proceedings in Ireland, that cost was a factor, and that the fact that she might be identified was also a factor, and all of those, she said, were inhibiting features which she said justified her not bringing proceedings in Ireland. The state argued against all of those on the basis that she wouldn't necessarily have been identified, that decisions can be handed down quickly. That happened in the X case, and that arrangements are often made to deal with the question of costs, such as lawyers acting on a pro bono basis. And those were all arguments that were taken into account. But I think certainly it's a lot to ask that ladies perhaps in that condition going through a stressful period would have to mount proceedings. So that in and of itself is probably a reason why not many people do it. A combination of factors of cost, concerns about speed and identification.
Yes. I'll take one more question from over there. Yeah.
Hi, Tara Kane here from Table 8. This is more a medical question. If the time comes where the doctor has to provide a phone number to a female to travel abroad for an abortion, our question is, on her return into Ireland, is there any aftercare? Is there medical aftercare or counselling, any care provided by the state to that female?
Absolutely, and I alluded to it in my talk. We would see it as imperative that patients would not be judged, and if they made that decision, they will get an appointment, they will get a card with a direct line phone number, and we will go to considerable efforts to have that patient back for a physical checkup to make sure that they've recovered from the procedure, and also for counselling as appropriate. I might say that, you know, counselling comes down the list of, if we go back to the resource issue, and I think maternity hospitals do not have enough counsellors, and we're sometimes struggling. We do the counselling, the midwives do the counselling. Do they need more professional counselling? Many of them will, but I think there is a gap. There's a gap there, but we will do as best we can to try and make sure that we get them through the process as best we can.
Could I ask in broad terms, how would you rate the availability of aftercare for somebody who comes back?
I would rate it good. I can only speak for my own hospital, but I know in the Rotunda and the Coombe they would work very similarly, and in Cork and the smaller hospitals, I'm not so sure as to what level, but I would hope and expect that they would all offer to see patients back. But you can see a patient back for 1 or 2 visits, but we don't have the resources if someone is seriously psychologically traumatized, as some of them are, who go on and develop depression and everything else. Then we obviously have an avenue to psychiatry, but again, there are 3 in the country. You know, who are. We've heard that last week. So there is a resource issue in terms of. I'd like to say it's much better. I think we do as best we can, and they would all certainly be offered. And if they don't turn up, we'll certainly try and encourage, and we liaise with the GP. And the GP is a very important person in dealing with the whole post-event, if you like.
I'll take one final question.
Hi, I'm facilitator for Table 5. One question that arose, it's a legal question, so for Eileen Barrington and Dr. Noel Higgins. Do you think it's possible to legislate for life-limiting conditions, or is this area too varied on a case-by-case basis to be able to define a rule on, or rules on paper?
Are you saying legislate without an amendment to Article 43.3?
Are we saying either?
Either, yeah. Eileen.
I suppose then there are possibly 2 answers. The first question is it possible to legislate at all for fetal abnormalities? And certainly, as I've outlined, the position of the state is that it isn't possible to legislate, because such legislation would be unconstitutional. There is an argument that is not correct, but certainly that's the view that has been expressed, as I understand it, by the Office of the Attorney General and taken on board by the Minister for Health. And that was outlined by the Minister in his speech to the Dáil. The view might be taken that legislation can't be adopted that would be consistent with the Constitution. If there were an amendment, or if the view were correct that such legislation could be adopted, then you're asking perhaps a more difficult question is, how do you go about defining what is a fetal abnormality? And certainly one of the objections to the bill that was proposed and debated in June and July was that it used the phrase incompatible with life, but didn't provide for any guidance or definition as to what that meant. I suppose in part it is a medical issue. Do you, in your legislation, for example, provide for a list of conditions that are considered to be conditions that would be where a termination would be permissible, or do you attempt to define life-limiting conditions or conditions incompatible with life in a different way? It's certainly a difficult issue. It would have to be considered, and it's one that would have to be considered in conjunction with medical experts.
Yes. It is unquestionably a difficult question, unquestionably. I think we will leave it there. We may cause chaos in the kitchen if we don't. I just want to repeat my gratitude to our four speakers for their presentations to us earlier and for answering very difficult questions and for really, I have to say for myself, enlightening me, and I hope you are enlightened as well. I'm sure you are. So you might just show a bit of gratitude at this stage. All right, we're going to break for lunch now and we'll recommence at 2:30. So 2:30.